Hello, welcome everyone. We're here to discuss Tareekh Pe Justice. Um, I would like to welcome everyone in the audience and the authors. So the format that we've decided is that I just give a brief introduction to the book and the context of the book. And maybe we'll have questions for the authors and then they'll discuss their perspectives. Um, all right, so the book, like was mentioned, was introduced, Tareekh Pe Justice, Reforms for India's District Courts. It explores the systemic dysfunctions plaguing India's district courts, which are the crucial first point of contact for most Indians seeking justice. And they kind of say in conversation that they derive their inspiration from the famous movie quote, Tareekh Pe Tareekh, Tareekh Pe Tareekh. I'm guessing that's what informed the title as well. Now, district courts, the reason they discuss district courts and the reason why we are having this discussion as well is because the district courts handle the bulk of India's litigation. And they are marred by delays, inefficiencies, and as their book points out, lack of independence among the judges of the district court. The authors point out that most discussions on reform have focused so far only on resources, by which they mean judges, funding, etc. And they argue that this misdiagnosis hides deeper institutional failures, like in one instance, judges, their appointment, tenure, transfer, performance, flawed oversight by the higher judiciary. And so they explore the hidden side of the system, what they call as the Kafkaesque inquiries, arbitrary dismissals, and the chilling effect this has on judicial courage, leading towards risk-averse conservative judgments. And all of this, the reason we would want to discuss this is because it has a real human cost. And the cost is on, and this cost is on everyone else involved, which is litigants. It has an effect on the society. It delegitimizes rule of law. So with this short background, I'll invite the authors in whichever order they would like to discuss, maybe set more context on the core problems that the book wants to highlight. Maybe Prashant, would you want to start?
Yeah, I'll start. Thank you, Varsha. So as Varsha introduced the book, the focus is on district courts in India. So just to give you some background, India has a three-tiered judicial system. You have the Supreme Court on the top, high courts at the second level, and then district courts at the very bottom of the judicial pyramid. And it's these district courts which actually hear the most number of cases, which are the first point of contact for most litigants. So for example, if you want bail, you have to go to a district court. It's a judicial magistrate who decides questions like remand after a citizen is arrested by the police. You have contractual disputes, labor disputes, your family court matters regarding divorce, custody of children. All of these disputes land up before the district courts. And the delays that we have seen before the district courts are extraordinary. I'm sure all of you know someone who has a case pending before the district court, whether it's related to land or a contractual issue or a family law matter, which just drags on for ages. Yet this layer of the judiciary actually doesn't get as much attention as, say, the Supreme Court or the High Court, which are seen as the more powerful courts in the system. So our idea was to refocus some of the debate on the district courts, because this has a very immediate impact on the lives and liberties of ordinary citizens. You can have a great constitution giving you fantastic fundamental rights to liberty and equality, but none of that makes any difference unless you have a well-equipped district court which can tackle these issues and give out remedies to citizens when they require them the most. But in India, as we have generally seen, the focus tends to be on the sexier issues, which is, say, the Supreme Court and constitutional law theory. The district courts are very, distinctly unglamorous places. You can see that reflected in law schools, in the legal profession, and even in publishing. You won't find any other book that's been written on the district courts in the recent past. So one of our chief objectives with this book was to shift the focus of not just, away from the Supreme Court and the high courts, but also the types of issues that feature in the conversation on judicial reform. So for example, the general focus is on lack of judges and the lack of money, the lack of resources for these courts to function. And we try to argue in our book that, this is perhaps not the actual reason. There is a lot of funding that has been provided to the judiciary over the last 20 years since the UPA-1 government. And judges, there are some shortages, but it's not uniform across states. Instead, we try to focus on issues affecting the judiciary in its quality of work. So for example, one of the first issues that we look at is how free are judges to make their decisions? Because the assumption generally is that the judiciary is independent and it can deliver justice without any pressure or fear. But as we try to point out in our book, they may be independent from executive influence. That is, the government cannot influence the district judiciary because of the way the constitution has been written. The high courts have complete control over the power of judicial administration of the district courts. But that then means that district court judges then have to worry about how high court judges are going to treat them. And that's where the first layer of the problem starts. I'll hand it over to Chitrakshi to give more details on how high court judges can influence outcomes in the district judiciary.
Yeah, so following up on that, so the way our constitution is designed, what we have done is that it works on the logic that as long as high courts are the custodians of these district courts, because they can exercise control over these district courts, they are sort of treated as independent from the executive. And what we find in our work is that, in fact, their independence is threatened by the way they are administered by these high courts. So to give you an example, there are many ways in which high court judges have considerable influence in deciding the career progression of judges who staff these district courts in each state judiciary. Their entire promotion cycle, their disciplinary inquiries, whether they will be compulsorily retired at a particular milestone age, whether in fact they will be confirmed in service. All of these decisions are taken by judges of the high courts, and the manner of this decision making is not only not transparent, it also has many gaps in the way these rules are designed. So to give you an example, the judges of district courts are governed by the same rules of disciplinary discipline and control that apply to the state civil bureaucracy. So they are governed under the same rules of discipline, in the sense that it's the same rule that is being invoked when you have to discipline a judge and when you have to discipline civil bureaucrats. The difference is that instead of a state legal department or a state department, it will be the high court which is exercising that head of department role. So the inquiries that are initiated against these judges are primarily supervised by high court judges. The process, and this is, we are looking at it in the context of disciplinary inquiries particularly. So what you find is that disciplinary inquiries are inquiries where there is a complainant who has a complaint against a particular judge, and you would presume that these complaints are related to corruption or misconduct. But what we have found in our research is that, in fact, in a lot of these cases, there is no allegation of corruption or misconduct. And a lot of the times, these inquiries are initiated because it was found that there was an error apparent, or they thought that the judge was too liberal in granting bail. So the bottom line here is that oftentimes these judges don't have any immunity even for their judicial decisions and their legal reasoning. And that is a very problematic scenario, because you would presume that the judge at least is free to make these decisions. But the outcome of these inquiries is that, given that There is no charge of corruption that is being levied against these judges in a lot of these cases. We have found instances where the High Court has dismissed or suspended judges on the basis of the fact that they have been too liberal in granting bail, or they have been too generous in giving some compensation related to a land acquisition matter. And these are really problematic scenarios because if you see in other jurisdictions, there are judicial conduct rules. In the United Kingdom, for example, the investigation office cannot really investigate on a particular complaint unless it is backed by some evidence of corruption or misconduct or bias. And they have a qualified immunity for their legal reasoning and judicial making capacity, which we do not have in the rules that currently govern the judges of the district courts. And as an outcome, the high courts can use the vagueness of the way these rules are framed, which are primarily supposed to apply to the bureaucracy, and they don't really distinguish between the functions of what a judge does and what a bureaucrat does, and they can use these vague standards, apply them to judges, and then punish them as an outcome of these disciplinary inquiries.
And you make a very interesting point. In the book, you talk about fearful judges, right? But the other point you also make, and something which many of us would not know, is the idea of the young judges. And I don't know if you'd want to speak about that and maybe connect that to the earlier point about the kind of threats that the judge feels to decide.
Yeah, so, I mean, one of the strange features of the Indian judicial system is, the average age at which lawyers become high court judges is generally around 50, right? If you're an exceptional judge, exceptional lawyer, you can become a judge even at 45, but the general rule is closer to 50, between 45 to 50. And that's the rule in most countries, where judges tend to be in their 40s, late 40s or early 50s when they take office. But somehow when it comes to the role of the judicial magistrate and the civil judge, so this is the first tier of the Indian legal system. The judicial magistrate is essentially the guardian of civil liberties, because anytime a person is arrested, he's produced before a judicial magistrate within 24 hours. And he has to give, and the magistrate has to decide whether the arrest is legal, etc., and whether the police can get custody. It's a crucial role. In India, for some reason, for the longest time, we had no requirement for lawyers to have any practice experience in the courts to become a judicial magistrate or a civil judge. So people were just writing their, graduating from college, preparing from the judicial service exam, and then becoming judges at the age of 25, 26. There are cases where people have become judges at the age of 21 years. So in some states where we had the data, like in Madhya Pradesh, we discovered that the average age to become a judge was around 27 years. So these are really, really young people who have very little exposure in courts or in practice. They also have very little exposure in life. I mean, because they are graduating college at 21, 22. They've lived in a very sheltered environment. They're probably preparing for the judicial service examination, living in a hostel or their parents' house. They've probably never even negotiated a rent contract, with a landlord. By the time they are, sitting in a position of power, deciding the life and liberty of a lot of people. And this plays out, and this becomes worse in the context of what we just discussed, where high court judges wield so much power and influence over the lives of district court judges. Because then you have these very young, very inexperienced judges of 25, 26 years old who are double thinking every decision because they are worried about what is going to happen in their career appraisal and what their high court judge is going to say. Because when they become judges at 25, 26, they are looking at a career up till 60 years in the judicial service. You make even one single error somewhere where, high court judge gets upset with you, you're going to be chucked out of your job. So the consequences are very, very dire, right? So this inexperienced judges issue has come up recently again. The Supreme Court's tried to revise this thing where they've said that now they've made it mandatory to have a 3-year practice requirement before courts, before you can become a judicial magistrate or a civil judge junior division. But that is still very little. Like in the United States, to become a magistrate in the federal judiciary, and this is a position which is at the bottom of the tier of the federal judiciary, and they exercise only a fraction of the powers of a judicial magistrate. The average age at which they're appointed is 50 years, and the average years in practice that most of these guys have is 23 years in practice. So every other country prefers to have more experienced lawyers, because a lot of the law is just experience. Like the number of cases you're dealing with, you learn a lot of, about humans, about the law, about life. And in India, we are still going ahead with, young adults who have just 3 years in practice.
Yeah. And I think you also make, and this for Chitrakshi, you spend a considerable time discussing judicial administration, and I'll also come to the reform in a little bit. And one point which really kind of, I think would resonate with a lot of us is the idea of data, right? And I quote from your book, which is The Folly of the National Judicial Data Grid. Data everywhere, but not a drop of insight, right? I'm taking it from there. Given that India is in this huge spurt of datafication, how would you kind of look at judicial administration and what you found in the book, and square it with the discussion on making information available, making data available?
So the national, I'll start from the data problem and then go to the judicial administration problem. So if you look at the National Judicial Data Grid, it only tells you some very crude statistics about pendency, which is court-wise, etc. And this has begun after the first phase of e-courts, which was in 2005. The policy action, the document in 2005, which wanted to create a system of statistics, and what we have now is the National Judicial Data Grid, which publishes these statistics in real time. And as we point out in the book, there are many gaps in this framework, which is that a lot of relevant statistics are not being captured. So the primary thing that is of use to, given the fact that the judge's time is actually the most scarce resource in this whole ecosystem, there should be a way to measure how much time is being spent on a particular case by each judge. And we don't have such relevant statistics being collected. The second problem in the way this data is collected and published is that we assume that there is a significant overcounting of cases, because as a case proceeds through different stages, there are multiple sub-stages where you will have interim applications, etc. And for a lot of, especially some categories of crimes, etc., there are a lot of overcounting which is happening. And we haven't put a quantitative measure to that, but there are other researchers, Pavitra and Bhargavi, who recently came out with a figure that at least in the Bombay High Court in the original jurisdiction, their data shows that there is an overcounting of approximately 66%, which is huge. So the problem is, of course, the first, that relevant data is not being captured and published, and second, that there is a massive overestimation of pendency and disposal. And this I will actually connect it to the other problem, that given this massive overcounting of pendency and disposal is also linked to the way the judges at these courts are being evaluated. So what these courts have is a system of assessment called the unit system, and this methodology has been devised by each high court. So under this system, each judge is given a target of disposal. So for example, in the Delhi High Court, the unit system says that to get a rating of good, you must have disposed at least 300 units in a quarter. And so these units are assigned on the basis of different categories of work. If you examine a witness, you will get a certain number of units, and so on. And you have to meet that target. And our hypothesis is that given that they have this incentive to dispose of certain units in a timely fashion in the period of time which might differ depending on which high court has issued these rules, they are in fact incentivized to dispose of easier cases first, because then they can earn those units. by disposing of the easier cases, get the rating of good or average, which is needed by these rules. And it's quite likely that the more difficult and complicated cases will they will drag their feet on it. And this system of assessment has to also be seen in combination with other administrative practices like transfers. So not only are you disposing of cases to earn those points, you also are aware of the fact that you will be transferred out of the district or that portfolio within the district soon. So the complicated cases are not really your problem so much. Someone else, your successor, will have to deal with them. So it is these two things, the unit system, the way the overcounting actually assists them in getting those numbers, and the way it interacts with other administrative practices, which is leading to a situation where you have the easier cases being disposed of first, and the more difficult and risky cases really not becoming priority in that queue. There will be some rules which will say that you will be awarded some extra units if you dispose of older cases, but the system as a whole doesn't really encourage the disposal of long, complicated cases by the judges of the district courts. Now, coming to the problem of judicial administration and linking it to the problem of statistics is the insight that, in fact, in the court bureaucracy, they do not have very efficient people to collect this kind of data. So ideally, you should have statisticians who are trained properly. But what we have found is that these judicial ministerial services rules, they are fairly anachronistic, they are old, and they don't really reflect the needs of a modern legal system. Perhaps they should consider looking at the eligibility criteria for a lot of these positions, or in fact rethinking the kind of administrative support that the courts today need. And of course, the other problems are those of vacancies and the way this entire court bureaucracy is recruited and managed, which leads us back to the problem of the High Court administration, because most of this work is in fact done by administrative committees in the high courts, and it is assisted by an army of registrars who are actually just district judges who are on deputation at the high courts. And this can lead to several problems. They are not professionals, of course, and of course they have no training in management or any other task that they are assigned as part of their administrative workload. Perhaps Prashant can continue.
If I can just add one thing, for example, when we say that cases are being overcounted, how the system is currently counting cases is, if there's one FIR filed, right, and there are 5 people arrested, and all 5 have to file bail applications, each bail application is being counted as a separate case on the National Judicial Data Grid. And this National Judicial Data Grid has been built after investing 2,500 crores into the digitization of the entire judiciary. And the entire e-courts program for which this 2,500 crores has been spent has been under the control of Supreme Court judges, right? So they have had the money, they had complete control over how to design the project, and they made a complete mess of it, as a result of which 75 years after independence, or almost 80 years after independence, we still don't have a proper system of collecting something as simple as judicial statistics. So when you hear these figures in the news of 5 crore cases pending, etc., that is not the right figure. That's definitely a gross over-exaggeration. We don't know exactly by how much they are overcounting it, but we definitely know that they are overcounting it. And the tragedy of this is that we had an excellent system of collecting judicial statistics while we were under British rule. It's one of those awful things to say where, the Britishers were more efficient than our own countrymen, because we know these reports are publicly available. They're called administration reports on civil and criminal justice, where if you want to, you want to do a research project on 19th century district courts in the Madras Presidency, you will get far more accurate data from 1879 than you will get for 2015, right? So this is one of the critical problems with a lot of the judicial reforms discourse in India, where we have the judiciary very, slyly exaggerating the tendency to bargain for more resources with the government. At the same time, when they get more resources, for example, when they get 2,500 crores from the government to build and design a proper ecosystem, they do a bad job of it. And the reason they do a bad job of it is because they are completely unaccountable. Nobody can ask the Supreme Court judge questions on how this money has been spent. And the reason for this is because the judiciary has been designed in such a way that it's meant to be independent from the executive in how it functions. And yes, it should be independent from the executive when it comes to issues of deciding actual cases. But when it comes to spending public money and where they're taking critical calls on expenditure of public money, they need to be accountable to somebody, whether it's parliamentary standing committees or the Comptroller Auditor General, which is a constitutional auditor. Unfortunately, that's just not the case. We have seen instances where a parliamentary question has been raised. So the government forwards that question to the Supreme Court or the High Courts asking for information in order to respond to a parliamentary query. And the High Courts and the Supreme Court have refused to give information. And in fact, they have said, there are cases where they have said that this will impinge on our judicial independence. They've invoked bizarre provisions in the Constitution on privilege for judges to deny giving this information to the government. So we have come to a stage now where this is a bad time to bring this up, because we're at that juncture in Indian history where there are dire questions being raised about judicial independence, and we're very cognizant of that. But we also have to think about accountability when it comes to judicial administration. Because if the judicial administration is going to be controlled by High Court judges, there has to be some way where we can ask them for, at least accurate information, and they have to play their part in that. Because unless there is some kind of feedback loop and there's transparency in how these institutions are functioning, the district courts will never reform. And if the district courts never reform, we are just not going to have justice in our lifetime. And the consequences of that are, encounter killings, demolition drives by municipalities, which enjoy widespread support from the middle class.
And on that point, right, on the point of reform, you make some very innovative and somewhat drastic kind of recommendations. I'm going to pick one now, and we'll probably do the others as well, which is the idea of separation of the judiciary. Maybe Chitrakshi, you could start. Separation of having the centralized and the decentralized courts at two levels, if you want to discuss that perhaps, and then we'll talk about the others that you've mentioned in the book.
Yeah, so that is the question of, like, given that we are a federal country, it might be a better idea to have legislations that are passed by the parliaments being adjudicated upon by a class of courts which is funded entirely by the union government, and the state legislations are being, in fact, a little bit resembling the structure in the United States, where if it is really a state legislation, then those courts are funded and and managed by the state governments. Not in of course, assuring judicial independence, the selections will remain independent, but it should be two different classes of courts, because what is happening now is that a lot of union legislation is giving rise to litigation which is ended up being adjudicated upon by these courts. And then you come up with other solutions like tribunalization, and they fall into the same, gaps again. Like, there is a considerable pendency in tribunals again, and there are again allegations of capture by the bureaucracy. And given the fact that we have an institution which is of the courts, which is seen to be more independent, perhaps it's a better idea to have two classes of courts, rather than having the structure that we have now, which in the architecture has a sort of central union judiciary.
Yeah, if I can just give some more background to the issue. When the Constitution was being drafted, one of the issues that came up was, should we have a system like in the United States, as Chitrakshi was saying, where you have one set of courts to hear disputes arising out of federal law, and another set of courts which are state-specific, which hear disputes that arise only under state laws. At that time, they gave Parliament the power to create additional courts to hear disputes under parliamentary laws, but that provision has never been invoked since independence. So as a result, what ends up happening is you have a system where basically your district courts here, for example, in Kerala, are all funded from your state government taxes, right? So your state government has to do the planning with the High Court on how many judges you need, how many courtrooms you need, and what is the budget going to be. The problem now is Parliament tomorrow can enact a law, like they did this in the 80s, where they made check bouncing a criminal offense. Parliament didn't consult any state legislatures. They decided to make it a criminal offense because of some other reasons that the central government was worried about. Now, the moment they made it a criminal offense, courts are flooded with check bouncing cases. And who does that burden fall on? It falls on your district courts in Kerala, which are being funded out of the state tax revenue. It's not like the central government is increasing its allocations or giving you money to create extra courtrooms. And this keeps happening, where the union government just keeps creating new offenses without factoring in how much litigation it's going to generate and whether resources are going to be available at the level of state governments to create additional courts, appoint additional judges, to hear disputes for issues that are very close to the heart of the union government. For example, debt recovery, because they own all the public sector banks, right? In the 80s, they decided that district courts in states are working very slowly. So we'll create our own courts, which are the debt recovery tribunals. And they took it out of the purview of the district courts. And now debt recovery tribunals hear these cases exclusively. So whenever the union government thinks it's an issue of priority for them, they will create their own courts and take matters out. But if it's not a priority like check bouncing cases, the states are left to saddle the consequences of what happens. Now, a simple way to deal with this issue is, like Chitrakshi was saying, create two sets of courts. One set hears only disputes under parliamentary law. The other set will hear disputes under state law. And this would basically resolve at least some of the issues, in the sense that now, tomorrow, if the union government decides that they want to create new sets of offenses, their responsibility is on them to provide the additional resources that are required by the judiciary to hear these kinds of cases.
There's a discussion, actually picking on both of what you mentioned, may be helpful given that we are situated in Kerala, which is doing a huge exercise in terms of datafication of their courts. I wonder if you had any thoughts on that based on your research, on the exercise or on what you found during your own work. I know it's not directly something you've dealt with. It's a new thing that's happening in Kerala, but I wondered if you want to reflect on that also.
Should I start?
Yes.
Yeah. So I think the nice story here is that it really shows that if a high court is more enterprising, it can be more amenable to reform than otherwise, where you have a project like the e-courts, which is more centralized in its planning and programming. So one of our criticisms of the e-courts program has been that it is managed and planned entirely by the E-Committee of the Supreme Court of India. And while membership has been extended to some high court judges in the committee, it's primarily a very centrally run affair between the E-Committee of the Supreme Court of India and the Department of Justice at the Ministry of Law and Justice, because it is responsible for the funding. And in the second phase of the e-courts program, they had decided that the implementation part of e-courts will be delegated to the high courts, but the planning and the standard setting is still very, very centralized. And had that program not really been had it not been so centrally designed, perhaps you could have seen more experimentation by the high courts in the way the digitization program took place in each state. And you could have had different examples where we see now that the Kerala High Court is being enterprising in the way it is trying to use digital data, etc. I think the critique of the e-courts program primarily is that it was very centrally planned and therefore did not lend itself to encouraging competition between different high courts, with them experimenting with the kind of design that they wanted for their district judiciary. It also would have perhaps, so there is no reason why two different courts, like two different courts in different states should have the same standard of capturing data. So each state perhaps can have its own way of identifying what it considers important in terms of collecting and publishing that data, and we could have had different models of that digitization project.
That's really interesting. I wondered if you wanted to talk
Yeah,
about
I
it.
mean, so, see, like, just to give you an analogy, you know, like a lot of, I'm sure, from what I've been reading in the news, the Kerala government has a lot of issues with the union government because of this excessive centralization of power and finances in Delhi. So the high courts basically have the same problem with the Supreme Court, where the Supreme Court has just taken over the power of administering the judiciary by taking control over this entire digitization push for the last 20 years. In fact, what we try to argue in our book is that this arrangement is unconstitutional because the way the constitution is written, the high courts are supposed to be in charge of judicial administration of the district courts, right? And digitization is a core issue when it comes to judicial administration. So this power should have from day one have existed entirely with the high courts, where they get the money from the central government, but they design their systems and are responsible for enforcement from day one. Unfortunately, that never happened, and you've got this system where the Supreme Court is sitting in complete control of the design of the e-courts project, because of which it's been done so poorly. If I can just give you an example, you know, when government offices were being digitized, for example, you take income tax, tax departments, or Ministry of Corporate Affairs, etc., the focus was on digitizing workflows, right? So within whatever was being done by paper in the government office, you would replace it with a computer, and you would make it more efficient and more accountable, because there'd be timestamps, etc., when the process is happening. You'll cut down on corruption. You don't have to bribe a peon now to transfer a file from one bureaucrat's desk to another, because now it's just going through the computer system, and there's a timestamp. So you know when one bureaucrat has finished his task and another one is supposed to start it. Now, these are the very same issues that are there in judicial administration, in court registries, because the court registries have bureaucrats who are as inefficient as the ones in government. But that digitization project never happened like that. We spent so much money. 20 years later, if you go look at the e-courts project, it's like a joke. There were government websites in 2005 which were 10 times better than what the e-courts website now is in 2025. And that's one of the problems, where if you centralize design issues when it comes to the e-courts with the Supreme Court, where we are very confident that the moment it is decentralized to the level of high court judges, they will in fact do a better job, because they have more incentives to reduce their workload when it comes to administering the district court judges. And they will probably also integrate very well with local police and local prison administration. Because, you know, today we're in a scenario, if you remember when Shah Rukh Khan's kid was arrested, he was in jail, he got bail, he had to be in jail one extra day, because the law then required the order from the court to be physically deposited in a box outside Author Road Jail in Bombay before 5 p.m. for the person to be released on that day. In this day and age, we're depending on letter boxes and a physical copy of the bail order being deposited in that letter box. I mean, why don't we have a system where you can just shoot out a certified, like authenticated email to the prison superintendent and let the guy out? So we have to ask serious questions of what the Supreme Court has been doing with digitization, because it's a lot of money, and it's our money at the end of the day.
On that note, just one point before we open it out for questions. The other very interesting aspect you discuss in the book is about giving power back to people through the introduction of juries. And that's something I think even for the audience to reflect on, but you could just trigger that debate by discussing the proposal that you had about juries. Either of you could start, and then we'll probably open it out for the audience as well.
Let me just start. So, I mean, India, as some of you may know, used to have a jury system until 1973, which basically meant that common men and women, actually used to be mainly men back in the day, would be hearing cases of certain importance, like sessions court cases, basically, like where the offense could be punished with more than 7 years in imprisonment. And they would make decisions on guilt or innocence of the person, wherein there would still be a judge in the courtroom, but the judge would only decide procedural issues regarding evidence and what kind of evidence can be admitted into trial, and he would hear the motions for bail, etc. But when it came to innocence and guilt, it would be these ordinary jurors who are coming from different walks of life who are deciding the innocence and guilt of their fellow citizens. Now, the people who hate juries, as we've written in our book, are lawyers and also judges. These are the legal elites who have extreme contempt for the jury. And they were the ones who were actually behind the push to abolish the jury system, as a result of which now justice has become an extremely technocratic process in India. There are a bunch of lawyers and there are a bunch of judges, all with law degrees, speaking a language that half of us cannot understand. Even those of us with law degrees sometimes can't understand what is happening in the courtroom. And that's how a system ends up losing legitimacy in the eyes of a common person. But Chitrakshi will give you more detail on some of these issues.
So we make a case for, of course, reintroduction of juries in our book. And there are several normative advantages of having juries. Chief amongst those is the fact that juries are seen as a guarantee of judicial independence, and the fact that the judiciary is working independently, because lay, ordinary people participate in the adjudication of a particular crime. And it's an institution which is, it's in fact a right to trial by jury is recognized in more than 2/3 of the world's countries, at least when it comes to crimes. So this is not something that is, we want to introduce. It is in fact a well-cherished institution. Very recently, there are proposals in England which want to take away the right to a jury trial in some offenses, especially when the sentencing is lesser than 7 years. And there is an uproar, there is outrage, because people want to believe that this involves the communities in the justice delivery process, and it in fact creates an environment of trust in the legal system, because people see justice being done. It can, a lot of the times, being in the courtroom can alienate ordinary people, and therefore your doubts about whether this process is in fact serving the interests of everyone and not just the elites can become you can have serious doubts about that if you're not really part of the process. Juries are an institution where you can participate in the adjudicative decision-making process. And there are several other advantages also. It can serve as a check against cynicism. If you are a career judge, if you've spent a long time on the bench, you can have your own prejudices. And this is not to say that the jurors will not come with their independent prejudices, but the chances are that perhaps you will be in a jury with someone who is maybe pro-establishment, and maybe there are some people who are very anti-establishment. So perhaps the collective decision-making in that institution will moderate either bias on either side. And there are several other advantages, which is that it can also serve as a security against corruption. Most Indians perceive the district judges to be extremely corrupt. And if you have an institution like the jury, you will have to not only bribe the judge, but also an appropriate number of jurors. So it can be seen as a security against judicial corruption. But the chief advantage, of course, is that I personally think, and we think, that there is a crisis of legitimacy which is facing our district courts. And therefore, to encourage lay participation in the courts, it may be a very good idea to reintroduce juries, which was an institution which till 73 was established in some parts of the country. For example, in Calcutta, Bombay, in Greater Bombay, the jury trials were being practiced till the 70s.
Yeah.
So it was not uniform. There were some states which abrogated the trial in the 60s, and it was never uniformly spread. But there were definitely some areas where these jury trials were a common practice.
I mean, clearly it means that some of us here have to give up control, because all of us are lawyers speaking here. But on that note, I would really want to welcome members of the audience. If you can say your name or introduce, and then maybe. Thanks. And you can also say if you want to
Yes.
someone to speak.
No, I wanted to talk to all three persons. In fact, you were telling about all of you being a lawyer. We are both advocates from the High Court of Kerala. So I was just listening to the speech and how it was stated that you were particularly asking how the High Courts of Kerala system is improving nowadays. Now, I would like to give a reality check upon that. It was stated that the Supreme Court judges and the High Court judges might be having some kind of disparity between their opinions, and the entire implementation system can be affected because of that. But as per the practical ground has to be seen, at least in the area that we are living right now, there is no disparity such existing. Because I have my senior here, she has been an active member of the bar for around 20 years. I have been here for 4 years. So we've been in constant touch with the bar and the bench. And the bench has been in extreme support of digitalization of the entire system. So there exists no disparity, or rather there exists no less cooperation between the High Courts and Supreme Court. On that note, if a more coordinated system has to be happen with these both High Courts and Supreme Courts, then the entire idea that the parliamentary section should be done by a different court and the state section should be done by a different court, if we are aiming at a more cooperative system between the High Courts and the Supreme Court, I am of the humble opinion that it wouldn't be so. If parliamentary section is meant to be dealt with somebody, state list is meant to be dealt with another people, then the disparity, if at all it exists, the disparity will only be enlarged. That is what I have been feeling. Now, with the e-court system, I do technically acknowledge that the e-court system's interface is probably something that the government might have had in 2005 and that the crores has been spent on it. But has it been effective? Yes. Because we receive calls from our clients on a daily basis. They go to the e-courts. They have a user-friendly interface. A person who has been facing a trial, an accused in a POXO case or a bail applicant, they can go to the e-court site. They can take up the decision. They can understand the procedure. Now we have another platform that is known as DCMS, which facilitates e-filing. Now if you take up DCMS, if you go through the advocates portal, everything, literally every other fact that we have applauded, even in the past, that comes. So even the e-court system, though it might have had its flaws, though its interface might not be fancy, for a common man, from a practicing lawyer's point of view, it has been effective.
Yeah.
People has been using it despite the amount of fund that has been funded.
Yeah, I mean, this is very good to know and
But in
nice
what-
to discuss. But yeah, I think
But
they
in,
should
like
reflect on it.
what is e-courts doing now that you couldn't do before? Just accessing orders. Can you place I know in Kerala this is possible because the High Court has worked outside the e-court system to make it possible.
Yes.
But in most states, something as simple as getting a certified copy of an order, there's no functionality on the e-courts for that. I've seen clients run around begging for, bribing people in the registry to get a certified copy of an order. And like the government, for example, Ministry of Corporate Affairs, if you want certified copies of, say, corporate affairs documents, they had a function 15 years ago where you could just click a button on their website, pay the fee, and it would be mailed to your office. This is one example I'm giving you. There will be, there will be some clients who can see that what is the next date of hearing on the e-courts website. But digitization could have done so much more. They've tapped less than 10% of its potential. That's the critique of the e-courts project. If you compare it with a e-governance program run by the central government, where agencies dealing with millions of documents like Ministry of Corporate Affairs or the IP office, the kind of functionalities that you will see there, e-courts has 1/4 of it. And we need to ask, why is that so? Why is, who's responsible for it? And why haven't they developed a better system?
Yes. With regards to that, I would also like to take that example of the Shah Rukh Khan's incident. It was stated that the order was not physically produced, but that burden, in my opinion, that burden could not be shifted to the shoulders of the judiciary nor the advocates. It has to be a state administrative measure that has to come. And I am personally of the opinion that it should be different from the whole judicial management system, and that it should be a more controlled by state administration system.
The problem is, how do you integrate the state prison system with the judicial system, say the district courts, if the design decisions for the software are being taken by the E-Committee of the Supreme Court.
That is definitely...
That is the challenge,
yes,
right?
that is definitely for the
Which is
government to come
why-
with the public policy for
Which
that.
is why judicial administration used to be on the state list before it was shifted to the concurrent list during the emergency, because judicial administration was always seen as a concern of the state, like because it is the closest connected to the
Yes.
general public,
Yes.
right? So why then is the Supreme Court E-Committee taking all these decisions? That's our only point. You give this power to the high courts. I'm sure they would have done this 20 years
Yeah,
ago.
but I'm just humbly disagreeing that there is no disparity between the High Courts and the Supreme Courts, and
Disparity in what sense?
that there is no lack of coordination, or there is no taking up of power just by the Supreme Court. I am of the humble belief that there has been happening enough delegation, at least as regarding the bar, that a bench that I practiced before, there are enough delegations that has been given by the Supreme Court to the High Court, and the benefits have been given to us as well.
Yeah, but look at you go ask your high court judges whether they can change the design of the e-courts program. They can't.
I mean, there's
I think they are also too busy to have this in their
so
minds.
just to give you more context, and
yes,
I'll also let Chitrakshi respond, but there's also the discussion that I think both of them made quite many times of where really is the funding coming from, right? The decision making is happening at one stage, and they call it the centralization, decentralization. I'm calling it the paradox, right? And if you are taking decisions, but it's not backed up by funding, then Kerala is an exception. The discussion that we are having about Kerala is an exception. But I think we should look at the larger country question and wonder who's really funding that, and what is the design choices that are influenced by that funding. So I think it's a bit of perspective, and I'm really glad, like I said earlier, to note that at least the bar here doesn't feel that dissonance, which is positive. I hope that's not misplaced. That's it. Chitrakshi, did you want to respond, or if you want to collect some more questions, maybe, and then you want to respond? Yes.
You have mentioned about the 2,500 crore, which has been, I'm not sure it is squandered away, where the money went. But my opinion, the active judges of Supreme Court, their job is to take care of the cases in front of them. And these purposes is extra work should be done to retired judges or senior lawyers, or if they are too busy, retired judges, there are a lot of them are there in Delhi and elsewhere. They should be given the job. This is my request. Secondly, you mentioned about a liberal bail given by a judge. Just 1 year ago, I'm saying this, I was a Supreme Court lawyer, so I know about the judges are very hard-pressed to take care of other things, like running this 2,500 crore scheme and all that. And almost 1 year ago, a very shocking incident occurred in Kerala. A man who killed his neighbor's lady was given a bail. In few days, he took the sword and entered the house, murdered the lady's husband and his mother also. And the children are orphaned. And the fellow said, I have done my duty. I don't care, I spend another 100 years in jail. So that's gone. So all what the state government did was just to suspend the SI. And what did he do? What they should have done was to suspend the judge for giving a bail to a man. That's what my opinion. So what has to do with the sub-inspector?
Do you want to respond
I'll answer the
first?
first question to the administrative duties of the judge, and then come back to the liberty of granting bail, etc., given to a judge. The first question is, of course, the fact that there is a lot of administrative workload that these judges have to deal with. And they are definitely not equipped in terms of their skills, or in fact, it is not even a fair use of their time to be spending so much on these administrative decisions. And so, of course, we make the case that especially for, because all of these functions of administrative policy making are also concentrated at the level of the high courts, who do this job collectively by sitting in administrative committees. It's a waste of their time. They should hire professionals, and there should be greater professionalization of judicial administration, especially when it comes to decisions related to budgeting, infrastructure, etc. And so that point is well taken, that of course there is a lot of administrative workload that can be delegated to professionals, although still under the aegis of the High Court, because we have to ensure that they remain independent. To the second question of the liberty of granting bail, that is of course a discretion that a judge has, and you've highlighted of course one incident, but empirically we are in fact going through a bail crisis where in fact judges are more than reluctant to grant bail. So maybe this could be a one-off incident, but most of the times, even when there is the accused has a right to bail, the judges would not grant it. And therefore last year, if the ex-Chief Justice of India, D.Y. Chandrachud, he had mentioned that the Supreme Court was entertaining close to 21,000 bail applications. And as a constitutional court, this should not how it should be spending its time. And that's just a reflection of the fact, a symptom of the fact that in fact the district courts are very reluctant to grant bail, which is why matters such as ordinary bail applications have to reach the Supreme Court. So maybe one incident should not be seen in isolation. You should see systemically that in fact judges are more than reluctant to grant bail, which is a right.
In fact, you should buy our book. Because we've outlined a lot of cases where judges have been fired for granting bail liberally. So what happens is the registrar vigilance will pick out 30 orders out of 3,000 orders and say, you have granted bail incorrectly here. There's no evidence of corruption. They infer that you have been influenced by extraneous consideration because you have granted bail liberally in these cases, not following some obscure precedent. And it's happening very frequently, sir. It's happening across states. And that is one of the big reasons that judges are terrified of granting bail today in India.
Okay, sir, last question.
Just one
I
question, yeah. I was going to say, please ask. a question.
So I'll just cut it short to two questions. First is regarding the introduction of juries, right? So the minute you say jury, my mind goes back to two things. One is cases such as the O.J. Simpson case, because a lot of people with a lot of social capital will obviously have a much bigger hand or a much bigger advantage. And then looking at India's own unfortunate history of khap panchayats, which are even happening somewhere around here in this current era also, jury system look like one that is actually extremely judicially and constitutionally sound. And sort of drawing from that, my second question is, even when we talk about juries, we're actually going back to something that already existed, right? We're not exactly looking forward. So why isn't India, or why is India so reluctant to look at, let's say, restorative justice or even transformative justice practices? Because that is something I'm personally interested in. So that is something that came up to me when we were talking about juries and like sort of changing the landscape of how justice looks like. That's it. Thank you.
Yeah, I mean, I think we were just looking at ways that you could improve the legitimacy of the judicial system, right? Because there is a crisis of legitimacy which, which judges never want to admit. But you see it in the way of encounter killings and all of that, which enjoy support. And so we're thinking just bring back the common man into the courtroom. It's educative, they have a role to participate, it forces all parties to play by the rules. Now see, the cases that you're bringing up of, celebrities being, have special rights, or, caste panchayats, how caste panchayats have worked. But you could raise the same issues with professional judges, right? They can be overawed by celebrities, and there are umpteen number of misogynist, casteist judges in India. At least when you have a jury, you at least have a more representative system. Imagine 3 Dalits on a jury in North India deciding the innocence or guilt of a Brahmin or of a Kshatriya person. That is transformative if you ask me. It changes the complete dynamics of how power flows in these communities. But Chitrakshi, you want to add something?
Of course, like in the selection of jurors, there can be representational safeguards, as Prashant mentioned, and that's all the more important because we know that marginalized communities are disproportionately represented in the under trial and the criminal justice system as a whole. So not taking away from that at all. Of course, there need to be representational safeguards in the composition of the jury, and they can be randomly selected after that in the juror roles, etc. Responding to your second question of restorative justice, so I don't see why restorative justice will not complement the existing criminal justice system. There are many restorative justice programs, say like victim offender mediation or surrogate victim offender mediation, that can complement the existing criminal justice system. The fact is that our existing system is in a crisis, and therefore you need institutions that sort of embolden the trust and legitimacy of that system, and perhaps And if we come to a situation where we also have the fiscal capacity to initiate these programs, we should of course try them. But I don't see them as breaking away from the procedure-led system that we have now. It can of course work as a complement to it. I hope I've
I
answered
think
it.
we've run out of time.
Yeah.
So thank you. Thanks for this engaging conversation. Thanks to everyone who's
Thank you.
been
And thank you for
Yeah,
the
that brings
questions.
us to the end of this session. Thank you, panel.